Everybody, Attorney Kyle Kaufman, hkklawoffices.com. In today's video, I wonder, are you a person who recently received a divorce judgment and you're not happy with it? All right, judge weighed in on your case, made your decision, you're not happy, and you're wondering what to do next. I'm going to dive into that in this video, but before I do that, guys, if you like what we're doing here, please like our channel, subscribe to it, leave comments, and of course, schedule a free consultation with one of the attorneys here. We'd love to talk to you about your family law case in Wisconsin. All right, so we get a lot of calls about this. People we did not represent, right? They go to court, they've now been divorced, they got the judgment, they had their trial, and they're unhappy with the decision, all right? Now, there are various different options, but I'm gonna talk about the three here that you can look at, okay? And they go in this order, and I'll circle back to them. The first is appeal. The second is what's called a motion for relief from judgment, and the third is called motion for reconsideration. An appeal, guys, is a situation like this. When your divorce is granted and you get your divorce judgment, that's what's called at the circuit court level in Wisconsin, all right? There's an appellate court, which is above the circuit court, and then there's the Supreme Court of Wisconsin. Some family cases can go up to the Supreme Court of Wisconsin, but before you do that, you have to go to the appellate court. So if you have an issue that happened in your divorce case that you think is appealable, you have to file a formal appeal. Now, at HKK Law Offices, we do not get involved in appeals. There's a reason for that. There are appellate attorneys who are very specific about those cases and their qualifications, right, and knowing what cases are appealable and what are not. And you really need an attorney who ultra focuses on that. What we like to do at our office is help you at the circuit court level. And first off, avoid a situation where you have to even consider any of these options, appeal or the other two I've mentioned, right? And so your first course of action is to hire really great attorneys like us who are going to help you, set you up for success so you don't even have to consider an appeal. And that's what we focus on, and that's why we do not focus on appeals, right? I hope that makes sense to you. But there are some situations where people hire us. Now it's post-judgment. They're not necessarily after an appeal, but they think something went wrong in the case and they want us to pursue some of these other options. So there's a process in Wisconsin. It's called a motion for relief from judgment. The statute section is 806.07. We call them 80607 motions. And within that statute in Wisconsin, the legislator has identified about 8 different reasons that somebody within a divorce action after judgment could pursue relief from that order. All right, now guys, I do not want you to leave this thinking that that is something that's very easy to do. It's not, okay? You need to engage in a lawyer, someone like us, come in with your facts and circumstances, hopefully a transcript from your hearing that you had with the court, right? And that attorney is going to review the record and determine if it fits within any of the 8 categories within the 80607 motion. What I can tell you is that we have been successful at that here at our office. We have successfully filed for relief from judgment and had divorce judgments reopened for valid reasons. So it can happen, all right? We've also defended against that, where the other litigant has come in and sought to reopen the judgment, and we've explained to the court after hearing and upon evidence why that relief should not be granted. So we're very familiar with that process. And again, it's not to say that your case will qualify, but you need to talk to an attorney to determine if it could, all right? The other option for you is what's called a motion for reconsideration. Okay, motion for reconsideration is something that happens very soon after your judgment, and you have to be very clear on the timelines for that. So if you're unhappy with your judgment, you should be immediately talking to your attorney if you have one, or a new attorney, to say, hey, I'm really unhappy, what are my options? What about a motion for reconsideration, okay? Guys, when you're thinking about a motion for reconsideration, what you're really focused on there is, did the judge do something incorrectly? Okay, did the judge mistakenly apply the law to your facts? Or did the judge omit facts? And somehow, essentially, the judge has made a mistake on a motion for reconsideration. The other option within a motion for reconsideration is there newly discovered evidence that was not available to you at the time of the trial, or not discoverable, meaning you didn't even have an option to find it, that the judge was not aware of for some reason, and you think the judge should now know of that newly discovered evidence and apply that to your situation so in order to change the judgment. None of these should be taken lightly. They're all very serious things: motion for reconsideration, relief from judgment, and an appeal. The key thing for you in the takeaway is that you you think about what happened in your case. You determine who's the cause of the problem. Perhaps it was your attorney. Perhaps it was a judge. Perhaps it was the person on the other side, okay? Your now former significant other may have committed fraud, deceit the court, failed to disclose evidence, hid it. That does happen, right? Who's the problem? What was missing? Discuss that with your attorney and what went on at the trial. And then from there, a properly qualified attorney like someone at our office should be able to give you the right route to be successful in those post-divorce options. And that includes referrals to good appellate attorneys. All right, guys, I hope you found this video valuable, and we'll see you next time. Thank you.